Yeah.
Okay, I think it's working.
Yeah.
Okay.
Yes. Oh, but we need Christina to do the time. Will you click the?
Thank you,
Okay,
Liz.
we're starting.
No, we can't start until Christina returns to start the timing.
Give us 1 second. Christina's coming right back. She's just grabbing the paper. Can you sign?
All right, Liz, we're ready with the timing.
It's been live already. I didn't want
No.
to stop it.
No, that's fine. I'm just saying we're ready in the courtroom.
Okay.
Everybody's muted. Good morning. All right.
Good morning.
And
Apologize for the delay.
yeah, go ahead.
Good morning.
We're going to go ahead and start. The Court of Appeals for the 8th District of Texas is now in session.
Thank you. Good morning, gentlemen. We are hearing oral argument this morning on United Fire Lloyds, versus JD Kunz, Concrete Contractor and Explore USA RV. This is case number 08-23-00047CV. And Mr. Kane, my understanding, just so that we're all on the same page, is your argument will be 30 minutes. Mr. Murphy, 15, Mr. Metzler, 15, and then rebuttal, Mr. Kane, an additional 15 minutes. Is that everybody's understanding?
That's fine, Judge. I don't think I'm going to need that much time, but I appreciate that. Thank you.
No problem. And just, we have the timer on one of the screens, and, obviously green means you can speak and continue, just like kindergarten, and yellow, you'll get a yellow light at 5 minutes, Mr. Kane, and for Mr. Murphy and Mr. Metzler, you'll get a yellow light at 3 minutes before your time is up. Okay, okay, terrific. We all have that understanding. And if it aids in your presentation, please rest assured that we have had an opportunity to read your briefs, the record, to discuss with the court the issues that y'all are going to present on today. So if that aids in your presentation, because I think the facts are, I'd hate to see you waste your argument time on facts and on issues, or on the context, which we've already had an opportunity to acquaint ourselves with. And with that, I will turn it over to you, Mr. Kane.
Thank you. May it please the court, my name is Kevin Kane. I represent the appellant, United Fire Lloyds. Basically, we have 3 main issues today. There's a 4th one, but I think the 3 main arguments we're going to try and focus on and hopefully get to today are the issue of 3 different exclusions under this insurance policy. There's the contractual liability exclusion, the your work exclusion, and the your product exclusion. Now, the first thing I want to make clear is that this is a duty to indemnify case, which is important and significant. This is not a duty to defend case where you sort of take the hypothetical, well, looking at the petition, could there hypothetically be a basis whereby there could be coverage? That's the duty to defend. And we looked at that issue previously. We determined hypothetically there could be without the case being tried. And so we did defend J.D. Kunz in the underlying lawsuit. The issue now here is the duty to indemnify. Once you have a trial that's taken place, the question is there in fact coverage? And the Texas Supreme Court in Gilbert talked about the standard that applies here, which is, I think, very important. It talked about the determination of an indemnity obligation is based on the actual facts of the case as proven and the language of the indemnity agreement. Other courts have used that same language and said slightly differently, but in the same way. For instance, the Fort Worth Court of Appeals talked about how the duty to indemnify arises from proven adjudicated facts. The Texas Supreme Court in the Trinity Universal case talked about actual facts establishing liability. Gilbert used that same language of proven adjudicated facts. And so what we're looking at in terms of determining whether or not there's a duty to indemnify is we're looking at proven adjudicated facts establishing liability. That's the standard of review that should be applied here. Now, the issue here, I'm sorry.
Excuse me, Mr. King, this is
Yes.
Jennifer. Are you suggesting that extrinsic evidence beyond the underlying lawsuit is not appropriately considered?
I'm not sure if you're referring to certain evidence, but the evidence should be what the court looks to in this case, certainly contained within the record. And beyond that specifically, what were the adjudicated facts in the underlying lawsuit? And so anything outside of that, we could speculate about maybe what people talked about or what certain things could have happened, and those kinds of hypotheticals would be certainly relevant to a duty to defend analysis, but they would not be relevant in a duty to indemnify analysis. So you apply that standard here to the first exclusion, that being the contractual liability exclusion. And in this policy, what it says is the insurance does not apply to, and I'm reading from the clerk's record at page 659. There's a number of places where the policy is found, but in that particular case, it says contractual liability. You don't have insurance where there's contractual liability for which the insured is obligated to pay damages by reason of the assumption of liability in a contract or agreement. Now that's the exclusion. Now the exclusion goes on to say, and it lists two different exceptions, one of which is not an issue in this case, and so I'm not going to talk about it because no one's claiming that the second exception applied. It is the first exception that's in dispute here. The first exception says, and here's what the policy goes on to say, this exclusion does not apply to liability for damages that the insured would have in the absence of the contract or agreement. Now, the reason why I'm sort of painstakingly pointing out, here's the exclusion and here's the exception, is because the Texas Supreme Court in Gilbert was talking about this very language in a contractual liability exclusion. And in that case, the insurance policy had a contractual liability exclusion that has the same language that ours has in our case. And what they said was that first part's the exclusion. That first part that talks about how that there's no insurance for a contractual liability that is assumed in contract or agreement. Then you look to the exception. The reason why that's important is because the Supreme Court in Gilbert said there's sort of a shifting burden that's taking place here. And whoever has the burden, that's always going to be relevant, whether we're talking about at trial or on appeal. But the burden here is important. The burden, the Texas Supreme Court said in Gilbert, works like this. It starts with the insured, shifts to the insurer, and then back to the insured. And here's how it works. It says if the insured proves coverage, so there's the first burden. If the insured proves coverage, then to avoid liability, the insurer must prove the loss is within an exclusion. And if the insurer proves that an exclusion applies, the burden shifts back to the insured to show that an exception to the exclusion brings the claim back within coverage. That's what the Texas Supreme Court said in Gilbert at page 124. Now, I think that's important because J.D. Kunz in its brief at page 29 argues this. They say It's irrelevant whether this term constitutes an exception to the exclusion or whether it merely restates what is implicit on the exclusion itself. I think it's very relevant, not the least of which is because the Texas Supreme Court specifically said there's a burden that takes place here, and there's a burden for one party over here, a burden over here. And when we're talking about the exception, which is what we briefed extensively, all the parties have, there's a burden that lies with the appellees in this case, the insured, to show coverage. That's not our burden as the insurance company. And so when we're talking about this exclusion, now the exception, and let me just say what the exception says and how some other courts have talked about it to break it down in hopefully the simplest terms so it's easy to understand, because it is a little complicated, at least in my opinion, but here's how it works. The first exception only applies if J.D. Kunz would have had the same liability in the absence of the breach of contract claim. Now here's what other courts have said. The Austin Court of Appeals says where the contract adds nothing to the insured's liability. If the contract doesn't add anything then other than what the common law already requires, then the exception applies. Ewing, this Texas Supreme Court said in Ewing, if it assumes liability that exceeds the liability it would have under the general law, then the exception does not apply. Or Ewing also used language, if it enlarges its obligations under any general common law duty. Now, the common law duty that they're referring to is what Ewing called at page 37, the duty to execute your contract with skill and care, or what other courts have said, and most courts say when dealing with this issue, they talk about the duty to perform your contract in a good and workmanlike manner. That's the general common law duty. And if what we're talking about, if the assumption of liability by way of contract is nothing more than just what is composed within the common law duty to perform your contract in a good and workmanlike manner, then the exception to the exclusion applies and it provides coverage. But if we're talking about something more, something beyond what's required under just the common law duty to perform your contract in a good and workmanlike manner, then the exception does not apply, the exclusion does, and there is no coverage. Now, here's what they've argued. They argue, Explore USA in its brief at page 18 and 19 argues this, and I think this is very important, because I think it cuts right to the heart of the issue. They say Kunz was found liable for breaching an obligation it owned under common law, not because Kunz failed to comply with the same obligation or some obligation that existed only by contract. The claims against Kunz did not arise from those additional obligations. The judgment against Kunz is based upon an obligation he owed under the contract and under general legal principles, an obligation to perform its work under the contract in a good and workmanlike manner. Now, I think it's very important for the court to take note of that, because I think that's the issue. I think that's the issue in this case. Do you have something more than just a general duty to perform in a good and workmanlike manner? What is the subject or the essence of this breach of contract claim? Now, what's interesting is when you look at Explore USA Brief's statement that I just read from at pages 18 through 19, when you look at that, look at the end of every sentence that I read. You will not find a single cite to the clerk's record, to the reporter's record, to anything. There's no citation. They cut to the heart of the issue, and then they don't give you anything to look to for this claim. And I think the reason why is because it's simply not there. The charge that was submitted to the jury simply asked this basic question. And I'm summarizing here. I may be a few words or articles off, but basically it said, did J.D. Kunz fail to comply with a construction contract? That's all it asked. So what's missing there is, do you have something in this case that, for instance, if you'd asked the question, did you breach your duty to comply with the contract in a good and workmanlike manner? Okay, that would be what the Texas Supreme Court was dealing with in the Ewing case. And in Ewing, the Texas Supreme Court said, if that's all you have, then no, you haven't got anything in addition to beyond what's generally required under the common law. However, and here's the important language in Ewing. Ewing's the case that they rely on extensively. They've tried to argue or lay this out as if I'm for Gilbert and they're for Ewing, and Ewing is better than Gilbert. I'm for Ewing and I'm for Gilbert. I'm for all those cases. They're still good law. They've not been abrogated. They're still binding authority. They don't contradict each other. You apply either of those cases and you're going to come to the same conclusion. Yes.
Mr. Kane?
Yes.
Sorry. You got on a roll there, and sorry about that, because I had a question. As far as for us, what we should look at when we make this determination, you mentioned look at the jury charge, but are we restricted to the jury charge? Or do we take our review a few steps deeper? Do we have to take a look at the petition, for example? Do we have to look at some presentation of the evidence? Or I guess I'm trying to get a feel for where you think the limits of our review lies.
No, I think you should look to the petition. In fact, they argue that you should look to the petition, and I agree with that. Kunz, in its brief at page 32, has a whole section entitled "The Substance of the Claim Matters, Not the Label." And I think that's exactly right. I think you should look to the substance of the claim and not merely the label. They've said we're arguing that there's the contractual liability exclusion applies just because there's a breach of contract claim. That's not our position at all. I've sent to the court, and I filed earlier this week, and I hope you have it. It's a chart. It was in our brief, but it was segregated on 2 different pages, and so I put it all on 1 page so you could have it. And here's what it does. On the left side, in the left column on the side here, this has allegations from their petition, and I think you should look at their petition. And then on the other side, I've got contractual provisions that directly relate to the allegation that they brought. And I think that that's important because they didn't just say, hey, you generally just should have done a better job and you should have performed your contract in a good and workmanlike manner. Now, they did say that in their petition, but they said a whole lot more. And the reason why that whole lot more is important is because of what the court said in Ewing. In Ewing, when the court dealt with this issue, they said a general contractor who agrees to perform its construction work in a good and workmanlike manner without more does not enlarge its duty to exercise ordinary care. And so
can I ask you then, since I'm not by trade involved in construction work,
yes,
it seems difficult for myself to discern, how do I interpret these allegations as being either just explanatory about where the failure to perform the ordinary work lies, or whether they cross over a threshold to taking on additional liability? You know,
okay,
we've crossed over the line to say it's more.
right. Well, I think the chart is designed to help with that, but let me see if I can explain it a little bit in terms of what's the more on here. The more in their petition and their allegations is this. And let me just kind of hit the highlights because I know we've got a lot to cover in a short period of time, but let me hit what I think are just the absolute clearest and simplest. For instance, if you look at that left column and you look at subsection D, these are all contained in paragraph 24 of their petition. At page 281. And there it says that J.D. Kunz failed to require written approval to hire subcontractors. There's no common law duty that says before you can hire a subcontractor, you have to get written permission. That doesn't exist in the law. So you can certainly contractually commit yourself to that, but that's in addition to what the law says. But there's no common law duty that before you hire a subcontractor, you have to ask for permission unless you create it contractually like they did. There's also, look at subsection F at the bottom, F and G. F says that J.D. Kunz's failure to properly procure insurance as required by the terms of the contract. And if you look at the contract on the other side of the chart, you'll see that there was a contractual provision that bound them to that. There's not a common law duty that you have to have insurance before you can do contract work. That certainly is a wise thing to do and a good thing to do, and it's often, frequently, contractually bound by parties who enter into construction contracts, but there's no common law duty to do that. There's no common law duty. I'm sorry.
All right. Are you saying then, looking at these 3 allegations that you just highlighted, subpart D, F, and G, are you saying that the jury charge is broadly stated and we could infer that the jury found that there's a failure to comply with these particular terms of the contract, and that supports the verdict.
In part, that's what I'm saying. What I'm also saying, Your Honor, is they have the burden to show that the jury based its decision that there was a breach of contract based on an allegation that was nothing more than the common law duty to fulfill your contract in a good and workmanlike manner, and they can't do that. And so that's sort of the flip side of the coin of what I'm saying as well. But I think if you look at any of these on this page, but especially D, F, and G, which I think are the easiest, but I think in all of these are all the more that was missing from the Ewing case. In the Ewing case, there was literally an allegation, and the allegation was nothing more than simply, you didn't perform your work in a good and workmanlike manner. That was it. And the court said that alone, by itself, without more, is insufficient. That doesn't show something beyond what's required under the general common law, and therefore the exception applies. We've got more here. And I think it's everything on this page, but especially I think it's easiest to see in the ones that we just highlighted, D, F, and G. And so when you go beyond the scope of what is just the general law requirements, I think this demonstrates this. But what they can't demonstrate, the inverse of this, because they have the burden under this exception, they've got the burden to show that what the jury did was they decided that whatever was the breach of contract, whatever was the conduct that breached the contract, whatever provision in the contract or whatever allegation they brought that was the basis of their finding of a breach of contract, that was within the common law duty of what's generally required for a contractor to perform their contract with skill and care or in a good and workmanlike manner. And they can't do that under the burden that's placed upon them by the Texas Supreme Court in Gilbert. And so that's the argument that we've got there.
Mr. King?
Yes.
Mr. King, setting aside, and I appreciate your point, and we have taken note of the point of those shifting burdens. Part of what I have a hard time dealing with here is the fact that, so we discussed that Gilbert calls us to look at proven adjudicated facts. And that's what you're looking at in terms of the underlying lawsuit. As my sister Justice pointed out, the jury question was a very general one about breach of contract. And when we look at how at least Ewing was interpreted by the Fifth Circuit Court of Appeals and Crown over, part of what I'm struggling with is the fact that they said performance in conformity with the contract documents is not dispositive in terms of the contractual liability exclusion. So I'm having a problem here with us saying that because it's a breach of contract issue in terms of the underlying lawsuit, that then we're looking at damages arising from how that was pled or pleaded and addressed in the underlying lawsuit versus what we're looking at here, which is the language of the policy itself. And I'm trying to reconcile all that, because as I look at Ewing and Crown over, I'm just not grasping how at the end of the day, when you have a concrete project or a system that has shown signs of failure, which is attributable to two things: the concrete not being consistently poured at 6 inches, and the rebar not properly being laid or somehow slipping down toward the subgrade. I don't understand how you want us to reconcile that, because are we looking at the project in the way that it failed, and ultimately whether the policy covers something more in terms of contractual liability than a good and workmanlike manner of performance, which is what you would expect in any concrete project? You expect that a good and workmanlike manner ensures that a system doesn't fail. And when you're looking at the reasons for the failure that were adjudicated in the underlying lawsuit, those two indications of failure were premised upon what was the specs of the contract. So if we understand that every contract is going to inevitably include specs, I read Ewing as supporting the fact that that doesn't necessarily get us to where we need to go in terms of the policy exception to the policy exclusion. that's what I'm wrestling with here. And maybe that's what you're looking at and what we're looking at. I want to make sure we're looking at the same things.
Right. I think what the appellees have done is trying to just look at this as just a general construction project and just say, and it failed. And therefore they didn't do their job right, and they should have done their job right, and that falls under the general common law duty. The problem is they pled more than just that. And when they plead those specifics in there, those specifics are what was missing from the Ewing case. And so what we're limited to is in looking at all of this, we've got to be able to, or not we, appellees have to be able to look and say, whatever the jury found was the breach of the contract. That's what caused the damages. And then the question is, okay, so what was it that was the breach? I mean, yeah, you could lump it all together and say, look at this construction project and there's a bunch of things going on here. And you're right, there is. But they've pled specific things, some of which I think fall within the general common law duty, and some of which do not. And so that in fact, I believe it was Kunz's brief, there was an admission on their part in which they said at page 33 that they said that some of the things that we listed when we talked about things that were outside the scope of the general common law duty, they said, well, there's some things in here that we didn't plead. And therefore, you shouldn't consider those. However, they admitted, in fact, they said, quote, these are not found in the common law. So they admitted there were contractual duties. They just said, but we didn't plead these. But they admitted that there were some that were not in the common law. Now, the problem was that came in the context of us pointing out everything that you see in this chart. And then there were some other things in the contract that I added in there, and they picked out the ones that were in the contract that they didn't plead, and they said, so just disregard those. Well, that's fine, but they ignored all of these, and all of these are important.
Well, let me ask you a more specific question in that regard then. To your point that all these are important, explain to us how D, F, and G are relevant to the damages issue as covered by your policy.
I'm sorry, I've got a little bit of reverb on this, and I'm trying my best to listen. Could you state that again, please?
So to your point about, quote, all of these are important, explain to us, please, how D, F, and G are relevant to damages as contemplated by your policy.
D, F, and G, that's the approval to hire subcontractors, that's the procuring insurance, and the subcontractors insurance as well. And and your question being is, if they said that was the basis for the contractual liability, that how does that relate to the damages? And my response to that would be, I don't know. That's a proximate cause issue that could have been raised on appeal in that case. So I don't know how that would work. However, the jury found that because of whatever breach they found, that it caused all the other damages. For instance, one of the other damages is E, quality control. Well, quality control is something that falls within the purview of the general contractor, which is J.D. Kunz. And quality control is something that was contractually required by them. And so, again, that's another something that could have caused these damages, or subsection C, providing all the labor for subsurface preparation. Okay, there's another specific item that says here, you specifically got to be responsible for the preparation of the subsurface, and that falls on J.D. Kunz, a contractual provision that requires that. And so it was that led to everything else that happened. But whatever that is that caused that, those are the damages that were found. The problem is, it's not my burden to show how that works in terms of the exception. It's their burden to show how it works with regard to the exception. I mean, I'm offering these things as here's ways in which the jury could have looked at this, and ways in which, the jury, one of the things the jury had in front of it was the contract. And in that contract, the jury could have looked at any of those provisions, and they weren't limited to the petition. They could have looked because the contract itself, the construction contract, came in as an exhibit. And as an exhibit, it comes in, and they could look at that, and they could look at any of those provisions, even one of the three that they said was beyond the scope of the general duty to fulfill your contract in a good and workmanlike manner that they said is outside the scope. They could have considered that. And so any of those could have been the basis. If you don't mind, let me jump quickly to, because I'm running out of time.
Can I ask you just one quick question, hopefully?
Yes, Your Honor.
Okay, what I'm hearing you say is it's not your burden of proof. So just hypothetically, are you telling us that Explore USA and or JD Kunz, if they had an incentive and an interest in ensuring that they had coverage for any possible jury verdict, they were obligated to ask the jury, do you find there was a breach of contract or a failure to perform in a good and workmanlike manner? And because they didn't ask that question or submit it as part of the jury charge, they're in a situation where they can't meet their burden of proof.
I don't know if I would say it's their obligation, but it's certainly their opportunity to do that. They knew before trial. If you look at the reservation of rights letters that's found in the clerk's record at page 806 and 807, in the last reservation of rights letter that we sent them that talks about specific exclusions that we're talking about, in prior letters we had said, here's a whole bunch of things, and then we narrowed it down in that November 20th, 2017 letter, I'm sorry, November 29th, 2017 letter, and we said, here's the three exclusions that we think when you finally get to trial may be problematic in terms of coverage, and that is the continuing or the contractual liability exclusion, the your product exclusion, and the your work exclusion. And so they knew before trial that all three of those were at issue, and they could have crafted and drafted questions that would have addressed those issues. Just like if you had a bench trial, for instance, and you were getting findings of fact and conclusions of law, you could ask the judge to talk about issues. What's the basis of the liability? You could certainly do that there, but even in a jury charge, the courts will allow you to segregate out beyond just the broad form submission when you have specific issues that you want covered, like if you have an issue of maybe damages and there's no evidence on some elements of damages, and that happens all the time, where you have a broken out, segregated jury charge question. You can do the same thing for coverage here as well. If their position was, this is just the only issue here is the general duty to perform your contract in a good and workmanlike manner, they absolutely could have asked the jury that question. And had they answered yes, then we'd be in a very different situation in talking about the application of the exception to the exclusion under the contractual liability exclusion. But they didn't. Again, I wouldn't say that it's their obligation, but it's certainly an opportunity that they could have taken advantage of at that point to make the process clear in terms of moving forward. However, what I think is clear in this case is that they have not met their burden. Your Honor, I see that I've got just a little over a minute left, and so I'm going to go ahead and stop at this point. I don't think there's a whole lot more I can, unless you have any other questions, a whole lot more I can cover in a minute. Thank you very much.
Thank you. And Mr. Murphy.
I apologize. I had muted myself. If it's acceptable to the court, I believe we request that Mr. Metzler use our time first, if that's okay.
Yeah, no problem.
Thank you, Your Honor, and good morning. I think I'm going to take a few minutes. I'm going to hopefully finish in less than my 15 minutes. And what I'm going to do is hopefully simplify this. And Your Honor, who is in the courtroom on my right, I can't read your nameplate, but I think you are hitting the point that I want to make. And that is that this is a case about a parking lot that's crumbling. And the jury points us in that direction when it answers question number 3, the damage question. It says what sum of money should be paid as a result of the failure to comply with the contract. Consider the following elements only: the reasonable and necessary cost to repair and replace the concrete. United Fire, at their own brief at page 52, says the only alleged and proven damage to JD Kunz's concrete work is to JD Kunz's concrete work, which is defined as your work, your product, or your work. So the only thing that we need to talk about and think about in this case is the property damage at issue, which is the parking lot. And why is that important? It's important because an insurance policy, I like to think of it as a blanket. The insurance company comes in and they have a contract in the insurance agreement that says, we will cover you for liability for damages resulting from bodily injury or property damage. So they throw this blanket out and they say, if you get sued for bodily injury or property damage, we cover you. And then they say, but we've got exclusions. And so we're going to take that blanket, and we're going to cut a hole here and cut a hole there and cut a hole here. And those are going to be the exceptions for the exclusion. And that's where we come to contractual liability. Kunz was hired to build a parking lot. Written contract or not, it had to be done properly. The verdict, as we just saw, is for the cost of repairing and replacing that parking lot. Therefore, the exclusion does not apply because he would be liable to pay for that and repair that regardless of a contract. It's good and workmanlike manner. You can call it supervision. You can call it hiring adequate subcontractors. You're the general contractor. It's your job to build this parking lot properly. That's the job. And you could flip that argument around. What if there was no contract? What if he just said, hey, I'll pay you $1.7 million to build me a parking lot? We wouldn't be here arguing this issue at all because there'd be no contract to do it with. There'd be no terms to look at, but he'd still be responsible under the common law for doing it properly. And that is the only damage that's awarded against him against the jury. The jury said, fix that parking lot. That's all we're concerned about. This interpretation is consistent with Gilbert, and it's consistent with Ewing. In Gilbert, that was a case where Gilbert was found responsible because of a contractual term that said, if some third party who's not related to this project suffers damage because of the work here, you agree to pay for it. And in fact, there was a flood that they related to the construction of Dart Rail, is what it was here in Dallas. And RTR was a property manager that had a high rise adjacent to it. And they sued Dart because of the construction project caused the flood on a heavy rainfall. Dart turned to Gilbert and said, hey, you got this contractual provision, you have to provide cover, you have to pay for that. That is not a normal common law obligation. That is an extra obligation that is created by contract only. And that's what that contractual liability excludes. Those arrangements that you make that aren't due at the common law. Ewing, by the way, is also consistent. It's crumbling tennis courts in that situation. And the exception to the exclusion was applied. And I don't want to get burdened down with whose burden it is to do what, because we've proved it. I'm already establishing the exception here because he owes this obligation. But let's look, if you look at Ewing at pages 33 and 34 of that opinion, they alleged failure to supervise, quality control, insufficient contractors, all that stuff's in there. Okay, but Ewing said the exception to the exclusion applied. Now, what's important too about this contractual liability exclusion is it's the only exclusion we're going to talk about today that deals with the theory of liability. All right. So we are done. Once you say he would have owed this common duty at common law, he would have had to pay the $1.7 million to fix the parking lot at common law. So he didn't expand his obligations. Then we're done with theory of liability. And what we talk about now is the property damage, because your work and your exclusions are exclusions that relate to property damage as defined by the policy. Both of them. Property damage to your product, property damage to your product arising out of it or any part of it, or property damage to your work arising out of it or any part of it. And fortunately, we don't have to learn what the product's completed operation hazard is. We don't have to deal with that. But that we are talking about property damage. And first, I want to deal with your product because I think this is the easiest argument.
Mr. Metzler?
Yes.
Mr. Metzler, again, focusing on the contractual liability exclusion. So to the same question, we posed this to Mr. Kane, are you then saying that on his exhibit for oral argument, D, F, and G, while they are in addition to the general good workmanlike manner required by common law, they are irrelevant to the damage that's covered under this policy?
Yes, Your Honor, and here's exactly why. If you look at the language of the contractual liability exclusion, it's property damage for which the insured is obligated to pay damages by reason of the assumption of liability in a contract or agreement. So yes, they assumed those obligations, but those obligations didn't cause the parking lot to crumble. And what we
Okay,
did, and
let
what
me
I,
ask you, understood. Let me ask you about E on the oral argument exhibit.
I don't have that exhibit in front of me, Your Honor. What is
Well, let
it?
me, I'll tell you. It says defendant J.D. Kunz failure to exercise quality control during the performance of their work on the project. So
That's just, if I may, that's just a specific allegation relating to get it done properly. He's the general contractor. Making sure the people are doing it right is part of his obligation as the general contractor. And that's part of good and workmanlike manner when you're building something. That's what the general contractor does.
perfect. So that doesn't bear on contractual liability, the contractual liability exclusion.
Go ahead.
So if it doesn't bear on the contractual liability exclusion, tell us whether it bears on the subcontractor exception to the your work exclusion.
It does not bear on that because I'm going to skip to that, the subcontractor exclusion. The way it reads is the exclusion does not apply if the damaged work or the work of which the damage arises was performed on your behalf by a subcontractor. We know that the subcontractors, from the evidence that was developed in the underlying case, which is what we rely on here, what the problems were, and we know that it was done by the subcontractor. You can say the allegation can be the lack of quality control, but it's the subcontractors that are doing the work. And the exclusion reads, it does not apply if the damaged work, that's the parking lot, was performed on your behalf by a subcontractor. And it was. There is nothing as United Fire would contend that says it has to solely arise out of the contract of the work of the subcontract. That's a word they add because that's how they want you to interpret it. That's not how it's written. The policy itself, it identifies Kunz as a general contractor who uses subcontractors. It knows what business he's in, and it's a general contractor's obligation to make sure the subcontractors do it right. That's their business. If they wanted to say, we're not covering quality control, then it should say, we're not covering quality control, but otherwise we'll cover your subcontractors. So remember, they have got to pull those things out that are covered by the policy, and they've got to establish that this parking lot did not arise out of work that was performed by the subcontractors. And there's no question it's the work of the subcontractors. The expectation is the general is going to be involved as well. Their response seems to be, well, we're only going to cover you if you're nowhere in sight and you've got no involvement whatsoever in the project. Then we can say it's solely the work of the subcontractors because you're not there. And that is, believe me, not what an insurance carrier wants. They don't want them not being on site when work is being done for which the carrier may ultimately be responsible if it's done improperly. If I could I got a few minutes left. I want to address the issue I think came up a couple of times about what evidence can be used. Again, we focus on the damage. How do we prove, and this is in the context of that subcontractor exclusion. How do you prove that it applies? You prove it by focusing on the damage, which is the repair that's reasonable and necessary cost to repair and replace the concrete. What caused that failure and who performed the work? And we went through the detailed evidence to point that out, all that exception. It's in our We rely a lot on Luke Roach who's the JD Kunz supervisor that was on site. And he goes through and he explains in detail that how everybody, all the subcontractors that took on all the different parts. And then we laid out all the expert testimony as the causes. The courts obviously picked up on it. The comments about subservice and the bricking problem with the rebar, all done by subcontractors. United Fire, by contrast, in their summary judgment at the trial court, not a single citation to testimony, not one. The word subcontractor appears once in its brief, and that's just in a reference to a subcontract agreement. In its primary brief in this case, not a single citation to evidence or testimony about those two issues, about the cause of failure or who performed the work. Only in their reply brief have they said what is missing is the direct evidentiary connection showing the jury found Kunz breached the construction contract because of work solely performed by subcontractors. It's not required by the policy, but what it does more than anything else, Your Honors, is it demonstrates they finally realized that it's covered and this is their last effort, is to say, you didn't meet your burden. Oh my gosh, they're right. If you look at their earlier briefs and what we dealt with at the trial court and initially here, it's just not covered. It's breach of contract. You can't get coverage for breach of contract. That's never been right. And it's certainly not right here. I want to address with my last 2 minutes here. One last issue I'd like to address, the idea that the jury charge should have been manipulated such that we had specific findings about subcontractors and who didn't. You know how we could have had that? If the defense counsel for Kunz had pointed a finger at the subcontractors and said, this is your work. But you know who's paying the defense counsel for Kunz? The insurance company. They've got no interest whatsoever in putting this on the subcontractors. That is completely contrary to any argument they're making here today. They already know the coverage issues. I was involved in this case that early on. That was their position. These are not the right kind of subcontractors. And so they're just going to take, hey, this is questions, great. And we all know, judges, I'm sure you've all been on the trial bench. Those broad form jury questions, that's what you're supposed to use. And if it's just Explorer USA and JD Kunz and they're the only parties, they're not going to get into all the specifics. You just ask the jury, is it JD Kunz's response? Are they responsible for the work that their subs did? Yes, they are. Did they breach the contract? Yes. What's the damage? So again, if we focus on what the damage is and how the damage was caused, it's easy to get through that contractual liability exclusion. It's easy to get around your product exclusion, and you get into your work, and that's where you get down and you dig into the evidence that was properly before the court, and that is what was the cause of the damage and who did the work. And it's clear that was all done by subs. I thank you for your time, Your Honor. We'll cede some time to Mr. Murphy.
Good morning. May it please the court. One of the things that I think we've tried to do in our briefing and also in oral argument from our side, and obviously Explore USA and JD Kunz are on the same side on these issues, is to keep things simple. I think we have to start with the law on interpreting insurance policies, which is that the policy must be construed against the insurance company and in favor of finding coverage. Another interpretation required by Texas authorities is that if there is an interpretation of a particular clause that is offered by the insured, and if that interpretation is reasonable, then that is the end of the inquiry. The court may not look at the interpretation that's offered by the insurance company at that point. It doesn't matter if the interpretation offered by the insurance company is as reasonable as ours or even more reasonable than ours. The threshold question is whether or not on any of these issues, interpreting the policy, if our interpretation is reasonable. If it is, that's the end of the inquiry. And I think Mr. Metzler has pointed out sort of an odd argument that, with all due respect, I think the insurance company is trying to really confuse some of these issues. One of the things that the insurance company is trying to do is to get the court to grab onto the idea that somehow the underlying case needed to be turned into the coverage case. So, for instance, the United Fire has argued that there should have been some sort of jury question on whether or not subcontractors did the work, or how much of the work was done by J.D. Kunz and how much was done by subcontractors. That issue was totally irrelevant at the trial, totally irrelevant. The issues of, and Mr. Kane is talking about this when it refers to the contractual liability portion, is to say, well, some of the duties that that J.D. Kunz got sued for undoubtedly would fall under this common law category that would be interpreted as a failure to conduct the work in a good and workmanlike manner, and those would be covered. But hey, there were other allegations made against J.D. Kunz, and those were specific to the contract. Failure to get insurance, which again, I don't think any of that is true, but regardless, failure to supervise the subcontractors. And hey, they agreed to that in the contract. That's not a common law duty, so therefore we don't know, and that should have been a jury question. Two things. Number one, for the contractual liability exclusion, that is an exclusion that the burden is on United Fire to prove. And we were under no obligation at trial to offer additional jury questions on which the jury could find some other form of liability. And in fact, if you look at the jury question that was submitted in this case, the only damage question that the jury answered says the following: consider the following elements of damage, if any, and none other: the reasonable and necessary cost to repair and replace the concrete. That's it. $1.7 million. That's it. There was no question for the jury to fill in the blank about, did J.D. Kunz fail to get insurance, and how much is the liability for that? Did J.D. Kunz fail to supervise a sub or get written permission to have subcontractors, and what's the damage for that? They were only asked, and that is the only issue in this case, is what the jury found, which was $1.7 million to replace the concrete. One of the issues that I think can get confusing is opposing counsel is saying, okay, look, even for the contractual liability exclusion, hey, we proved the exclusion, so they have to prove the exception, trying to shift the burden back onto us. The Ewing case says we don't have to go there. We don't have to prove anything at this point, because the damage for which J.D. Kunz was found liable was the parking lot. And in the Ewing case, I think it was incorrect. I think it was stated earlier that the only thing in the Ewing case that was alleged was that the contractor had solely failed to perform the work in a good and workmanlike manner. That's not right. And I think Mr. Metzler pointed this out. Here are some of the additional allegations in Ewing. Failing, I'm sorry, I thought I heard someone asking a question, but here are some of the other allegations: failure to complete the construction in accordance with the contract plans and specs, failure to manage the property.
Mr. Murphy, I do have a question.
Yes, Justice.
Okay, so, and my eyes are on the oral argument exhibit. I don't know if you have that, but the question I have is just, there's contract language, paragraph 7, that does say all work to be in strict accordance with the plans and specs. So I'm just wondering, are we supposed to assume that that exceeds ordinary workmanlike matter? That type of language is imposing the more language that might trigger a lack of coverage?
No, Justice Palafox. And the issue there is the Ewing case. And one of the allegations against the contractor in that case was failure to complete construction in accordance with the contract plans and specifications, failing to properly carry out the construction so that it was completed in accordance with the plans and specifications. That's exactly the allegations in Ewing. And it's exactly this fact situation in which the Texas Supreme Court said that does not preclude, that does not trigger the contractual liability exclusion. By its own terms say that it does not apply unless the liability is, and I'll quote the exact language, which the insured is obligated to pay damages by reason of the assumption of liability in a contract. It's the same exclusion in that case as we have in this case. And Ewing says it does not apply. And the other allegations that are in the chart that Mr. Kane provided, those allegations, to the extent they were not present in Ewing, at least under the opinion, those allegations were not the subject of the damage claim. So the only thing we should be looking at is the failure of the parking lot. So, Judge, there are two other exceptions that I think we need to talk about. One I want to deal with rather quickly because we're not spending any time on it, and I think that's because it's very clearly not applicable here, is your product exclusion. The United Fire spends very little time in its brief and spent no time in oral argument talking about it, I think because it's very clear that that is frankly a loser for them. The CU Lloyds case out of the Austin Court of Appeals says exactly squarely that in situations like this, the work of a contractor is not a product, such as a tile manufacturer or a pipe manufacturer. In that case, I think it was a house and the home builder got sued and the insurance company tried to use the same exclusion. Austin Court of Appeals said that is not a product. Product doesn't comply to construction projects. And so, Your Honor, obviously the Austin Court of Appeals would be controlling on this court as a transfer court. And so the argument in the brief even was simply from United Fire that CU Lloyds was wrongly decided. I don't think we need to spend any time on it. I think CU Lloyds is directly controlling in this case. As for the your work exclusion, Judge, obviously the issue we're talking about here is that we admit that we have the burden in this case to prove the subcontractor exception to that exclusion. I would submit to you that we did that very successfully. There is no evidence in the record, and I would invite the court to review the citations provided by United Fire that seem to imply that J.D. Kunz did something physically to build the parking lot. There is no such evidence. I've gone through the citations that are in United Fire's brief. I'll just be very quick. One of them, a gentleman named Luke Roach. There were only two J.D. Kunz representatives that were ever on this project. One was Mr. Kunz himself, who didn't do anything physical on the project. And one was a gentleman named Luke Roach, which was essentially the superintendent on the project. There were no employees other than that on this project, and no one physically did anything. And there's no evidence of that. The citations that United Fire are providing, one was Mr. Roach talking about what his responsibilities on the project were. This is on page 480 of the record. It doesn't say anything from Mr. Roach or anybody else that he physically did anything to build this parking lot. There's another citation from United Fire that seems to indicate that Kunz did some of the form cutting or form setting and saw cutting on this project. That is with all due respect, that completely misstates what he was talking about. If you go to, that's on page 335 of the record, he's being asked what JD Kunz normally does on local projects here in the San Antonio area, not what he did on that project. So that is no evidence that Kunz did anything. And I could go through the rest, but suffice it to say that we provided overwhelming evidence that the only people who touched the physical stuff, the machines and the concrete and the pouring and the finishing and the scraping and all of that stuff that goes into pouring a large parking lot, was only done by subcontractors. And I believe the court had a question earlier, do we have to prove that JD Kunz didn't do 0.001% of any of this work? And I believe the answer is no, we don't have to prove that. Yes, it is our burden. But look, if we haven't proven it in this case, with the avalanche of evidence over and over and over again that the subcontractors did all of the work, then there would never be a case in which any contractor would ever be able to enforce a policy through this exception. So all of the evidence at trial was that the subcontractors did all of the work. What is the work? It's not procuring insurance. It's not supervising. It is doing the work that caused the damage. And that is according to the exception itself under the subcontractor exception, which again gets back to the law on any of these terms, whether it's an exclusion or exception or anything else. These are all written by the insurance company, and they are to be construed against the insurance company. If United Fire wanted to write in its policy that says, okay, in order to trigger this exception, you, the insured, will have to prove that the subcontractor did 100% of any work connected to any of this, and that you were not involved in a supervisory position or any other thing, they could have said so. And they didn't. And because of that, we, by showing the subcontractors built the parking lot, we have proven and met our burden to prove the exclusion or the exception to the exclusion. And I'll, yes, sir.
Just a quick question, and I'll look for myself in the record as well, but if you know, did Query input the data into the laser screed to measure the concrete?
Let's see, Judge, I do have that. I believe, Judge, that is at the record at 1137, 1138. That Query was the one that owned and I believe operated the laser screed. And then at 1138, and this is Mr. Roach's trial testimony, that the subcontractor that operated the data or that operated the laser screed is also the one that entered the data into the laser screed, which in the page before he says was Query.
Thank you very much.
I do have one question, but it's just more about just a general understanding of your view of the trial record. What aspect of the work, regardless of who performed it, but what aspect of the work caused the parking lot damage?
So the testimony at trial from the various experts were twofold. One is that the concrete was too thin, was poured too thin in at least a number of places. I don't know if it was all over or in a significant number of places. Another expert, I believe it was a different expert, testified that the rebar should be, I'm using my hands and I shouldn't do that. The rebar should be in the middle of embedded in the concrete. And in this case, he found that it was on top of the concrete. And because of that, he testified that it would be hypothetically possible to replace parts of the parking lot, but that would be, because the damage was so extensive, it would be more expensive to do that than simply just to take it out and start all over again.
All right, thank you. Rebuttal.
Thank you. Let me get to as much of that as I can. First of all, let me deal with one of the last points that was made toward the end there about how you interpret this policy, and if there's an interpretation that favors the insured and it's reasonable that you must go with that interpretation. That's a true maxim of law for insurance law in Texas, and we're not disputing that. The problem with that is what you have to do is follow that up and say, here's a particular provision of the insurance contract. It's somehow ambiguous or subject to more than one interpretation. And so here's one that favors us, here's one that's favored them, and here's where the court should go. And that's what you didn't hear. They're not talking about interpretation. They're talking about application. No one has said you can't understand what this provision says. What they're talking about is the application of that rule, not the interpretation of that rule. You interpret it, you apply it based upon how you interpret it to the facts in a given case. But just because we're saying it should be applied to us versus them doesn't mean, well, if they're saying it should be applied in our favor, then general rules of and maxims of interpretation go in the insured's favor. That doesn't apply here. What's the provision that is being misinterpreted or interpreted or is ambiguous or can be interpreted in more than one way? They haven't pointed that out. So we're wasting our time talking about that. That's an application issue. Now, they also talked about the fact that Gilbert and Ewing, that the decision that was made in that court rested on the damages. I believe that's what Mr. Metzler said, that the opinions in those cases rested on the damages. I've read those cases inside and out, and I don't see anywhere in the analysis where they say, because we have this kind of damages, therefore we can make a determination as to whether or not the contractual liability exclusion applies. That's not anywhere in there. They didn't look at that. In fact, in the Ewing case, they looked specifically at the claims, the petition in that case. That's in there repeatedly. In Ewing, they talked about this. They said they looked at the claims that were brought and determined based upon that as to whether or not there could be coverage. They talked about Ewing argues that the express agreement to perform the construction in a good and workmanlike manner did not enlarge its obligations and was not an assumption of liability. They talked about other general allegations that were made in that case about complying with the contract, but there wasn't anything specific that was alleged within that could determine whether or not what was required under the contract exceeded the general duty to fulfill your contractual duties in a good and workmanlike manner. And so what the court said was, all we're dealing with here, they didn't say we're ignoring all the others. The assumption is that whatever it is that the others said, just basically generally doing what the contract says, that's part of your good and workmanlike manner. But when there are specific things within the contract that might exceed, like we have in our case, then that's a whole different matter. That's the without more language. But in its analysis, what they said was we're dealing with just the issue of a good and workmanlike manner. They didn't deal with anything else.
Mr. King, but doesn't the nexus inevitably have to be to the property damage itself? Because that's what your policy says.
That it has to be connected to the damages?
That's what's covered by your policy. So that's why we're looking at the relevant contractual provisions bearing on contract, the relevant provisions bearing on the damages. The damages are what were covered. And when we're looking at the damages in this case, the damages were not caused by anything other than what we understand to be an uneven concrete pour, not uniformly at 6 inches, and the improper laying of the rebar. So so we're not talking in generalities, and the reason we're not parsing out the reasoning in Ewing versus this case with regard to the damage, and the reason we're looking at specifically those points of the contract to determine whether they extend beyond a good and workmanlike manner requirement is because the ensuing property damage was a result of that work as opposed to these other provisions that you're talking about. We're not talking about technicalities, so we're talking about the actual reasons for the property damage.
All right. And so, go ahead.
So maybe if you could, what would help is if you could distinguish the contract provisions bearing on the actual work resulting in the property damage that you say go beyond general good and workmanlike manner of performance.
Okay, let me go back to the chart and point out some specific things in here, additionally to what we talked about earlier. We didn't talk about all of them. In subsection A, it talks about the incorrect placement of rebar, the thickness of the concrete, and the failure to comply with the diagram. And I've got the provision of the diagram directly across from that. Okay, complying with that specific diagram is not, that's not required, and that's not how you comply with general contractual duties under the common law. That's a specific thing that applies only to this case in terms of how you're supposed to actually specifically do the work. That's in addition to generally just doing your job well and doing your job properly. You also have...
If that's true, Mr. Payne, then explain to us what a possible contract would look like in a construction project that doesn't go beyond good and workmanlike manner. Every contract is going to have specifications. Are you saying that because there's specifications, that the rebar has to be, yeah, I mean, specifications? Doesn't that make the contract liability exclusion in essence meaningless?
No, I'm sorry. I'm focusing more on not just that the contract says that, but because they have specifically alleged that that's a breach of contract. That's what I'm talking about. So then the question is that specific conduct in terms of what they're saying you had to do under the contract, where they've segregated out the exact placement of the rebar, the thickness of the concrete, doing what this specific diagram provision says, is that in addition to the general duty to perform your work in a good and workmanlike manner? You have the same thing under subsection C, which is provide all labor for the subsurface preparation. You've got the same thing in subsection D. And so in all those, what you have is, but my point is that the things in terms of the incorrect placement of the rebar, the thickness of the concrete, complying with the specific diagram provision, and providing all the labor for the subsurface preparation, if that's what the court is looking for, those are more directly linked to the parking lot itself. However, what they've said in terms of that Gilbert and Ewing were contingent upon the kind of damages that were sought in that case, I encourage you to please read those opinions. You won't find that anywhere in there. They also argued that the underlying case needs to be a coverage case, according to my opinion. That's not what I'm saying. What I'm saying is they know going into that lawsuit that there's insurance at play. And they know that there's a dispute about insurance. And so they know that at some point in time, they're going to ask for coverage, and they know there's a coverage dispute, and they know what specific provisions we're saying are at play, what specific exclusions apply. And so they can address and remedy those. I'm not saying they have to, but if they want to address that issue and do what they need to do to have coverage, they can do that in the underlying lawsuit. I'm not saying that doesn't turn it into a coverage suit. It's still a breach of contract claim and a breach of warranty claim, and they still get those questions. It's just how they word those questions that's going to either help or hurt them when they have the burden. They also argued, and they argued under the your work provision. Well, first of all, they argued that because I ran out of time, that I think that that's a weak argument, which is interesting. Yes.
Okay, sorry. So can I just clarify, because I asked Mr. Murphy the same question, but does the contract provision that says all work to be in strict accordance with the plans and specs, in your view, does that contract term elevate the contractual obligation above a ordinary and workmanlike manner?
I think it does, because again, that goes to the specifics when you look at the specifications of the contract itself. And I think that elevates it to the more information that was talked about in Ewing. But I think all the rest of these that we've also talked about in this contract get there as well. Now, in the short time left, let me just talk briefly about the your work, because the reason why I didn't get to it is I ran out of time because there was so much good discussion on the contractual liability. It doesn't mean that I think this is a loser of an argument. And so let me talk about that briefly. They say here that it doesn't have to be solely like we've argued. Well, whether it's solely or otherwise, they've got the burden to show, because it's an exception to the your work exclusion, that this work was done by a subcontractor. And here's the problem. The underlying judgment was limited to liability only for J.D. Kunz, nobody else. There's no co-defendants that were added. There was no responsible third party. It was just J.D. Kunz. You can't sue the general contractor and then hold the general contractor solely liable and then turn around and rely on and blame the subcontractors when it comes to coverage. So there has to be something showing that what was done only by, and the reason why I say only or solely is because you had so much that was going on here. There's a number of different things that were happening here. And so, for instance, somebody could have been doing one project over here that didn't cause damage. Another subcontractor over here has done something. And then you look at the petition, and the petition alleges things that J.D. Kunz was doing that could cause a breach of contract. And so then the question is that when you're determining if the subcontractor exclusion applies, they have the burden to show that, okay, there was a lot of different things that were done, a lot of moving parts, a lot of different subcontractors, a lot of people working on this, including J.D. Kunz, and that's reflected in the allegations. And so was the violation that was found in the jury charge, was that solely caused by, was it caused by a subcontractor? Now, they've said that there's no evidence of a subcontractor because the insurance company is paying for defense counsel. I heard that. I think you heard it as well. That's a little offensive to say that the reason why we got here and the reason why there's no evidence on this point is because the insurance company was paying an attorney, and that attorney violated his ethical duties and didn't zealously represent his client, and therefore was just doing what the insurance company paid him to do, which is just basically, screw over the insured. That was basically the argument that was being offered. First of all, it's outside the record, so there's nothing to support that or prove that. I don't know because I wasn't there and I'm not in his mind when he's representing him, but we're not here to throw stones and make fun of and pick on someone who's not here, which is defense trial counsel, and say he didn't do his job and he was just doing what he did and did a poor job because he was being paid by an insurance company. Every insurance company that has hired me to represent a third party, I've always told them, I represent you, I don't represent the insurance company. And I tell the insurance company the same thing. I don't represent you. The best interest that I'm representing is that of my client. But on the issue of there's no evidence of subcontractors and what they were doing, again, when we're talking about subcontractors, whether there's evidence or not, that's not J.D. Kunz's attorney's problem. That's their problem on appeal if they want to show coverage, which they have to do. The bottom line is they could have in any number of ways involved the subcontractor. We didn't have to point a finger at them, but they knew if there's going to be coverage, we're going to be saying that subcontractors did this. And so they had some evidence that some subcontractors did things, but what's missing is evidence that the subcontractors did what they claimed. For instance, now I've pointed out in our briefing that they claimed that they had an expert who testified that the concrete was installed too thin and the rebar was improperly sitting on top of the subgrade rather than embedded in the concrete itself. And then they cite to the clerk's record at pages 1081 to 1086 and 1090 to 91. And I went and looked and read that, and I can't find that in there. But again, both sides have made this point, and so we're encouraging the court to do this across the board. Look at those clerk's record sites and see if they actually say what they say. They go on the same page of their brief at page 36, J.D. Kunz's brief, and they argue that that same expert explained that it was a subcontractor's use of a concrete pouring method called tailgating that caused these problems, and that's what caused the whole entire concrete system to fail. And they cite to the record again at pages 1094 to 1099 and 1002 to 1003, a separate set of 8 pages. And I went through and I read those, and I can't find it in there either. But regardless of whether that's true or not, and I don't think you can find it in there, but regardless, what they've got to show is that what the jury found as to the breach of contract was was caused only by subcontractors. In other words, if it was caused by somebody else, then you don't have coverage. The exclusion doesn't apply and it doesn't revive coverage. So I've got 18 seconds left.
I'm sorry, I
Yes.
do have a question. So we can see and we absolutely will discern for ourselves what the evidence in the record says.
Thank you.
But where in your policy does it qualify the subcontractor exception to the your work exclusion? In terms of, it doesn't apply if the subs do work a certain way, or if they do this or don't do that.
The your work exclusion, and I see that I'm about to be out of time, or I already am out of time. May I answer the question, please?
You can answer the question, please.
Thank you very much. The your work exception, here's the language of it, and here's what it says, and this is what we're limited to. It says what is excluded from coverage is damage to your work. This is in the clerk's record at page 662. It says damage to your work is property damage to your work arising out of it or any part of it and included in the product's completed operations hazard. So it's very broad language. Property damage to your work arising out of it. And your work is interpreted very broadly, or the definition within the policy that's found at page 673 is work or operations performed by you or on your behalf. Again, very broad language. And so then there's where you get the exclusion, which is really easy to meet because it's such broad language. Is this your work? And then there's a carve out, there's an exception, says this exclusion does not apply if the damaged work or the work out of which the damage arises was performed on your behalf by a subcontractor. That's what the policy says, and so that's all the court needs to look to in terms of interpreting or figuring out whether or not that exclusion applies. But again.
Okay. So when we look at the evidence and we look at the 5 steps of the process, and we see the evidence in the record proffered by, I believe, 4 expert witnesses, or 4 witnesses, excuse me. Are you suggesting that there is any step of the work that was not done by the 3 subcontractors mentioned?
Yes, I am. And just to shortcut this, I don't want to rehearse these arguments, but I've talked about that in our brief, and I don't have the page numbers in front of me, but we talk about testimony with regard to some of these allegations in there where there was testimony that J.D. Kunz did these things. Then there's conflicting evidence that we talked about that's in our brief in the your work section. And I think it's toward the end of that. And so I would direct the court to that. I don't want to go through it. It would take me several minutes, and the court has this briefing.
We have your brief, and we will absolutely discern the state of the evidence.
Thank you very much.
Thank you.
Thank you, gentlemen. You've made our job a lot harder. But we appreciate your presentation today in answering our questions, and the case will be submitted based on your presentation and the briefs. And so with that, we will adjourn. And thank you again, gentlemen. We appreciate it.
Thank you.
Your Honor.
Good day.
Bye-bye.